often have students who do the same thing, who believe intuitively, and I'm not defending the police or not. That's not the purpose of this, but I've been a prosecutor, a solicitor, a general assistant United States attorney, and now defense attorney. And a lot of my students in class, and we teach Miranda, wonder why anybody would admit anything. Surely the police must be secretly coercing them or lying. Well, why would anybody, after you're told what you say can and will be used against you in a court of law? But even before that, why would you tell a police officer anything? I mean, haven't you watched television? You know, if you watch television, you know your Miranda warnings. And the truth of the matter is, I tell them people confess. People want to talk for some strange reason. And I tell them one of the best things to watch is there's a show that was on Dateline, a thing that Dateline used to do some years ago called To Catch a Predator. And I don't know if you've seen that. They would set up a house in the burbs somewhere, and one of the guy that routinely did Dateline would do it like once a month. And they would they would contact these people on like Craigslist or these websites, and people would call in and they would talk to an adult that had a very childlike voice and say, sure, I'm 14, I'm 13, I'm here at home, come on in. Or I'm here, I'm at such and such address, just come by. I just want to see you. I just want to meet a pretty girl or a nice young boy. And of course, there's somebody in their 30s, 40s, or 50s. And Dateline would be in the back that had the house wired, and then the police would be down the street. And these guys would come in, and it's remarkable what they would do and say. And then the guy from Dateline would walk out with the microphone in his hand, you know, and approach them and say, you know, sir, what are you doing? There'll be no child. There's no child anywhere. You know, what are you doing? Why are you here? And the police would be in the back, and they would actually sit down at the kitchen table and have this long talk about why this 30, 40, 50-year-old man was interested in young teenagers, boys or girls, and just say all kinds, in front of NBC television cameras. So after that, I tell people, it's interesting why people confess, and same thing with gun cases. Why do they do it? When there's no police coercion at all, no trick. But I believe they try to talk their way out of it, and they fail miserably, of course. And at any rate, I just thought, if you ever have trouble wondering why people confess to guns or drugs or any other crime, To Catch a Predator has great videos, and the police don't come to the lady, but in front of NBC news cameras, and sitting down on the couch or the kitchen table, they will tell all. And they will try to excuse themselves, but they will tell everything. And so it's strange psychologically, but people seem to want to talk. So I offer that as to why people confess. It just demonstrates it. Henry, go ahead.
Thank you. My name is Henry Schlien. I'm a lawyer. I work in Somerville. I work a lot of cases with Miller, or you could say he helps me with my homework a lot of the times. I don't have all the experience that Miller has, but I was a policeman for 21 years here in Charleston, and as a detective I found that, talking about confessions, there's three gotta. Birds gotta fly, fish gotta swim, and people gotta talk. And it just is that way. I want to tell you, they have to tell you. I wanted to talk to you briefly about some firearms-related issues. First, your Second Amendment rights are some of the most important rights that you or your client has. They're enumerated rights in the Constitution, the first 10 amendments of the Bill of Rights, or the 1/10 of your civil rights. So just keep that in mind when you're dealing with things. I do a lot of family court work. The past year for me, it's been raining custody and visitation cases. Every time I turn around, it's custody and visitation. Well, what's that got to do with firearms? Well, everything. Because in family court, they issue restraining orders like they pass out water at a seminar. By state law, how many people were here last year for this study? Okay, well then you know, it's 20-3-110. The family court will give the restraining order restraining anybody, the parties to the case or anybody involved in the case from harming, harassing, or interfering with the other person's life or threatening them. And And that sounds a lot like the restraining order that is in 922, 18 U.S.C. 922 G8, that says if you're subject to a restraining order that sounds like that, restraining you from threatening or harming an intimate partner or child thereof. And of course, they add a requirement for a finding of a threat. But still, if you fill out a form to purchase a gun, federal firearms transfer form 4473, there is a question that says, are you subject to a restraining order restraining you from threatening or harming an intimate partner? And if you check yes, you're not going to be able to get that gun. And if you check no, and you found to have been subject to that restraining order, that's a 10-year, $250,000 federal felony for one. Now, what I like to do, if I'm doing one of those restraining orders, I say, well, sure, we'll consent to that, and sometimes we ask for them. But we'd like some language in there that makes it clear that it's not that restraining order that we're putting in there. We're just putting in an innocuous restraining order to keep the parties from agitating each other while the case cools off. Throw a blanket over it. So I like to add, the court makes no finding of any domestic abuse. The parties agree, and the court hereby requires that this is a mutual civil injunction only, and not one issued under any protection from Domestic Abuse Act, stalking or harassment statute, or for purposes of any state or federal firearms laws, including but not limited to Title 18 U.S.C. 922G, the Brady Act, the Federal Firearms Transaction Record, ATF 14473, or its successors, or any state law counterparts. So that just makes it clear. Most people don't have any problem with that. They'll say, what was that language again? So I give it to them. A lot of people email me, can you email me that language? So I email it to them. Don't agree to terms that say no bothering or annoying. Because bothering and annoying is a lot broader than harming, harassing, or threatening or molesting. Those are very broad, and some judges won't approve that. One judge told me he's not going to approve that because it's too broad. It's too basically overly restrictive. But just be careful what you're going to agree to.
You can annoy somebody just by being alive.
Hey, some lawyers like to say this. One lawyer was very annoying to me just by being on the other side of the case.
My wife says I'm annoying to her because I'm married to her, so that's the way I do.
Doesn't have to be accepted. But this particular lawyer came up with a restraining order. They said, I'm not going to gender anybody here, we want an order requiring that all firearms be safely secured under lock, and all ammunition be secured under lock, separately from firearms. Further, requiring that no firearm be in the vehicle in which the child is being transported, or on any person responsible for the care of the minor child. So, I wonder if counsel realized that their client was also going to be subject to this. And the lawyer said, I said, well, I don't know about that. How about something that looks like, how about just no unsafe or inappropriate access to firearms around the children? And they said, well, does your client have a gun? I said, this is the South. I don't know, don't care, didn't ask. Everybody's got a gun in the South. Yeah. And if you don't have one, your neighbor probably has more than one to make up for it. But we told the judge we were in agreement on all these things. We weren't in agreement on this thing. We'd be in agreement on something, but not that. So in the end, when the judge issued the ruling, it did not include any kind of firearms restriction. And there wasn't any showing that there was one required. It was just somebody's idea that we must take these precautions around children, I guess, wherever that person grew up. Now, if you're like Miss Deborah this morning, she grew up in Iowa, 8-year-old brother was given a gun on his birthday, and that was perfectly okay. Nobody gave a second thought about it. That was then. And if you're from some other place where it's illegal to take your gun out of the house, New York or something like that, regardless of what the federal law is, doesn't apply in New York City. New York state law doesn't apply in New York City. Well, okay, that's where you're from. This is not that. So what I'd like to say is, don't be too quick to agree to things when you're going back and forth with your family court or those kinds of things. You might be, without you realizing that it's something, I mean, who doesn't want to protect children? Who would want to protect children from firearms accidents? I mean, we know that they happen. But you know, somebody say, well, what do you have against protecting children? Don't you want to protect children? You know, like, and you might find yourself thinking, wow, I don't think there's something wrong with me if I don't agree to this. It sounds innocuous. But you might be abridging 1/10 of your client's civil rights. It might be important to your client, especially here, because everybody wants to go hunting and fishing. And it's more than just hunting and fishing. People have a right to have a gun to protect themselves, and you know, they have a right to have a gun. It's just your right. You don't have to have a reason. So your client might think that that's important. So make sure you involve your client in the process, as I know everybody does. Another point we wanted to talk about, we have a lot of cases where firearms are involved with federal court and state courts, and sometimes people call me and ask me, or sometimes they ask me, no, sometimes I say, well, here's my opinion, and ask me what his opinion is. And, sometimes, I think last year we had a case where somebody innocently came into possession of some firearms, machine guns that were, you know, maybe they were illegal from the get-go, but this person was not a gun person. This person just knew that he inherited some guns, or he stood to inherit them. The parent had passed away, and here were these guns, and what do I do with them? So police wanted to secure them. Don't leave them in the house. They're having to patrol the house. Oh, okay, I'll put them in some storage facility somewhere. And, you know, anything. One thing led to another. And that's not the only time that happens. A lot of people will get cases where somebody's got a gun, somebody comes into possession of it, and or guns, or something happens, and so the client says, "Well, I'll tell you what, I don't have a lot of money, but if you like any of these guns." Oh, and don't you think that client last year had some guns that I would have been interested in, but I ain't going down that rabbit hole. Because number one, it could be illusory. You don't know if the guns are ever going to come back or if they're illegal. And two, what we don't want to do is make the return of some guns from the government a priority for the lawyer in the case. So don't let the tail wag the dog. Don't put the pursuit of property ahead of the pursuit of liberty. For example, I'm not really taking a survey, but that everybody is aware that some people collect things. Some people it's watches, some people it's cars, depending on how much money you have. It could be houses. And some people collect guns. And whatever it is that you collect, those things have significance to you. You know those things. You make it it's your interest to know those things. If it's guns, you know. You look in the movie, you say, oh, that's not that gun, that's this other. You tell the slightest detail. The people who know those things, they see it. Some people, it's just a blur. But those people, they know exactly what that is. And certain types of guns, whether they're Colts or Smith & Wessons, those old revolvers or antique, you know, they mean something to those people. And I'll admit I'm one of them. You know those things. So, somebody has those guns and they get taken from them, well, they mean something to those people too. I was informally consulted, not officially consulted, but I knew somebody that would buy and sell guns at a gun show, and I know he didn't have a license. Everything would be private sale, so he would take the position he didn't have to have a license to buy and sell these guns, because everything was his private collection. You sell a gun privately. You can in South Carolina if you're an individual. You can buy a gun from an individual. You can sell a gun to an individual as long as that's a resident of the state of South Carolina and he doesn't have a federal prohibited factor like convicted felon, drug addict, restraining order, that kind of thing. As long as you're sure that they don't fall afoul of that, you can buy a gun from the person, you can sell a gun to that person. But there's a limit. The government takes the position that if you buy or sell more than one gun a month or more than 12 a year, buy and sell, then you start to look like you're in the business of dealing in firearms, and they want you to get a federal firearms license, the FFL. Well, if you have that, then you can no longer sell guns privately. You have to do paperwork and background checks and fill out that ATF form 4473 and keep track of it in case the government wants to come down and inspect the records. So, make a long story longer, I heard that this particular person got all his guns seized, got about $250,000 worth of guns. And it was mentioned to me, well, he should go, he didn't get charged, he should go ask for those guns back. They need to give him those guns back. I said, whoa, negative. He needs to do nothing about that. If he didn't get charged, he needs to keep his mouth shut. Because I knew that, just from what I kind of saw and figured, he had some serious liability for dealing firearms without a license. It could be a $250,000 fine or 10 years imprisonment for each transaction if they want to make that case. Certainly they could aggregate them and make it, lump them into one. If they didn't charge him by making noise to get that gun back, he can bring about those charges. And if he gets the lawyer interested in getting the gun for the lawyer's own fee or getting that gun is really important, and you adopt your client's position or need to have that gun back, because he keeps nagging you about it. You don't want to tell him forget about it. What did Al Pacino say? Forget about it. We all should say forget about it. That's what you got to tell the client. Forget about it. You're putting your liberty ahead of that property. That gun is just property that can be replaced. Or if it can't be replaced, your liberty can't be replaced. You can't get 10 years back. So don't go down that rabbit hole. Don't let the tail wag the dog. And I'd say be careful about taking things, can a client give you a gun for a fee? Sure. Have I ever taken one? Yeah, probably once. But I kind of knew what I was getting into, and I did that one time. But normally, no, I don't want to get paid in something. Let the client pay me in money. I'll put it in the bank and make a record of it, and then everything's on the books. And nobody can have problems the way we did business. At least everything can be above board and have a good contract.
We're good. 5 minutes.
Okay, we're doing good.
But I was going to say about federal crimes mostly. If you get something in federal court, federal court's just harder. The old saying, "Don't make a federal case out of it," and that's the first word. But as a defense attorney, you can't help that. So in federal court, you have legal issues pop up in one of three ways with most guns. One is how they seized it. That's a Fourth Amendment issue. So you're trying to suppress the stop of a car, the search of a house. You're looking over a search warrant. That's what you've got to do. Because gun cases in federal court, most of them come down to if you have it, if you possessed it constructively or actually possessed it, you're guilty. It's like the drugs. You got to get rid of the gun, period. It's not an issue what's a legal firearm or not. Most of them are legal guns. They're not a fully automatic or anything like that. But your client's a drug dealer or doing something else they shouldn't be doing, and the gun is connected with the crime. So they're a felon in possession, which doesn't make the gun itself illegal or contraband either. So you've got to get rid of the gun. You've got a search warrant issue. Beyond that, the next thing is the defense at trial. Is it a firearm? That's usually easy. They're just not going to indict a case in federal court normally if it's not a firearm. The ATF is very good. They know what they're doing, and you don't have a problem there. You might, but the big issue, the big driver in federal court, for those of you who know this, are the sentencing guidelines. And in federal court, it's the tail that wags the dog. I mean, the sentencing guidelines determine everything. And the sentencing guidelines in federal court just will gobble you up on firearms, even if they don't indict you for them, and how they stack them and the mandatory minimums of the statutes and how things work out. So I would advise you to take a hard look at the sentencing guidelines, take a sentencing guidelines seminar, because they will address guns somewhere in there. They will address the violent crime portion of the enhancement statute, the force part of this. And you need to look at sentencing guidelines and how they treat firearms. I have friends call me all the time saying, well, I've got this situation with a firearm, with a pistol, a client. The gun itself is not contraband, it's not illegal, it's not fully automatic, it's not a sawed-off shotgun. It's just a gun used in the course of another crime. And what they're trying to do with that gun to my client or to somebody else's. So you have to make yourself fully aware of the sentencing guideline provisions. There's a recent case in the Fourth Circuit that you should take a look at. It's called United States of America versus Joseph Sims, S-I-M-M-S. Not just guns, but in general, about enhancements. And it's from September of 2018. Don't think it has an official site yet. But you ought to get that if you're in federal court and take a look at it and get somebody's sentencing guidelines seminar notes and look at the cases and enhancements with respect to guns. Because most attorneys are making a mistake in that area. Their clients are being surprised. Well, it looks like the government's offering you a good deal. Just plead to the gun. We'll get rid of the drugs. Or they'll get rid of the drugs. And get rid of the guns and plead the drugs. The gun is there under the guidelines. The gun is still there. You can't make it go away. It's called relevant conduct, okay? A couple more things. Who would say go to the government to get advice? But you need to know how they think. So I'm seriously telling you to do that. There is a website, and you can get it on Google, United States Sentencing Guidelines Commission. That's all you have to type into Google. They have a fantastic website. They have huge documents and booklets that you can download. And for the most part, they're about 98.7% right. You can expect the judges to do that. It's excellent material. They have worked very hard. This is a government agency. Even when you disagree with them, this is what the United States attorneys and probation agents are going to do. Excellent materials here. They even have a calculator app now that will run your calculation if you know some things and put it in. Swear to God. How many people have that? You've seen the app? The guidelines? A couple of people. It's pretty good if you can put the stuff in right. But they have booklets on all kinds of things. Relevant conduct to keep them updated. Read over them. Have one on firearms. Read it. Please. That's where it is. The other thing is, and Henry's talking about the federal firearms license and selling firearms as a private. And I know of a lot of private persons who are big gun buffs, and they got 200 or 300 guns. There's nothing wrong with that. But with the friends, they trade them, they sell them, they pass them off, and I hear stories, and if I'm with them, I kind of say, you guys just be careful, okay? Like Henry said, so many a month, because right now we don't have an administration that's breathing down people's neck about this at the moment, but the laws are there, and if that changes, they don't need to pass new gun control. They just need to get tougher on it. So go to the ATF website. If you're a gun buff, you might say, I don't take advice from the ATF. Please do, because the U.S. attorneys and the probation agents, they do, and the ATF agents do, and there's a lot of material on that site. There are a lot of booklets and a lot of things that will tell you where you can get in trouble with just this kind of point about selling firearms. And remember, you may disagree with a lot of it. I actually think a lot of it is pretty darn good. I really do. But it's how they think. And use the ATF source. Use the United States Sentencing Guidelines Commission's website. It just has enormous resources on it. They're just absolutely enormous. And they can answer a lot of your questions. And you won't look, pardon me, so stupid when you go and try to argue with the U.S. Attorney, the probation office about things. That they're trying to educate you. The material is there on both of those sites. And so I recommend that to you. One other thing, like Henry said, other than having a gun that's in connection with drugs, that's what poisons the gun. I haven't had many gun cases as such about an improper gun. That's usually obvious. I mean, you can't have a fully automatic weapon without an appropriate license. You can't have a silencer without an appropriate license. And you can't have other things. So the people who usually get in trouble on that end, an improper, really illicit firearm, are one of two kinds of people. One, real crooks who know what the hell they're doing. And you usually know who that is when you get that as a client. And they just got caught. And then you just have to worry about whether the firearms statute's really classified, how they claim it's classified. And the federal government and the ATF are pretty darn good at that. And two, the other thing is a more typical case, and Henry and I have had a couple of cases like this. Like you said, where somebody, a father dies, a husband dies, and a wife or somebody has inherited a safe that's full of firearms and they have never looked in it. They don't know what's in it. That person needs some advice. Do not tell them to do things like, well, load them in the trunk and bring them down to the law office. I'll put them in the trunk, bring them. No, don't move them. Because, that might get there okay. We had to tell a client this. No, I don't want you to come where I live. I'll get a U-Haul, I'll put them back, I'll drive them back down. No. Well, I drove them up. We know that. You didn't retain us at that time. We would have never told you to do that, okay? But you took them out of state. What is the problem with stuff like that? If they're really ignorant about what they've got, you don't want them stopped for a speeding violation, just going through some podunk county somewhere, and they say, what's in the U-Haul? Guns that I got my father. How many? 200? 250? Really? That U-Haul's going to get opened up, and you're not leaving. The chances of those guns continuing with your client down the road are really negative. They need to put them somewhere safe and keep them there until some expert can look at those guns and say what they are and tell the wife, tell the son who may not have guns, what can you do with these? Because you can have, and we had a client just like this, had a fully automatic weapon. It had been modified. So the client didn't know this, but we had experts come in and agree with the right people, and they looked at all the guns first, and they said, do you have a problem here, here, and here? The rest of these are okay. Very, very valuable gun collection, maybe $500,000, right? Yeah. So, and we didn't get paid any guns there either, all right? It's tempting. That's about as tempting as I've ever been. But we made an arrangement with the ATF. They will work with you if you approach them. And we turned over the bad guns. They didn't like it because they were worth a lot, but to the wrong people, and he can't sell them because they're fully automatic. They've been changed. They've been altered. He didn't know that when his father had them. So, yeah.
Contrary to the common belief, most of the people in the ATF can be, I won't say your best, the lawyer ought to be the client's best friend, but the ATF can be right up there with the lawyer and try to help your client under the right conditions. I've worked with them my whole life. I've never run across anybody in the ATF that was vindictive or just trying to pass a personal agenda, as is the common perception in some circles. I won't say it doesn't happen. I've never run across anybody like that. They've been some of the coolest and nicest and easiest people to work with, both as a policeman and as a lawyer.
And one other thing that is on this, if you do have a client with a big cache of guns, a husband, an uncle, a grandfather passes away, and you've got 2 or 3 safes, and you have a lot of firearms, and they really look like they're of value. I mean, call somebody, like an attorney that does this, because we had somebody here today that didn't speak in the last session, who's a retired, not with the ATF anymore. And a lot of those people now kind of private detectives on the side that do some work. Get a former ATF agent, trust them, say, can you come look at these weapons, give me an eyeball, kind of broad notion of what I've got here. You can find people who will do this who are not going to report you. And they're going to come in and they can take about an hour or 2 with a couple of those guns, and they can tell you whether you have a problem or not, whether you have an issue. And it's worth it to get the peace of mind.
Oh, yeah. Okay. Well spent.
That's all. Any questions?
Anybody got any questions? Oh, come on now, we're not pushing up against lunch.
Dinner.
I got a question.
Yes, sir.
What would you suggest if you have a person who says they inherited, like you said, cache of guns, you tell them don't move it, don't do anything, and then...
As long as it's really safe where it is, that's a
right,
problem.
As long
yes.
as it's safe,
yeah.
But then 3 days later they call you back and tell you they've sold the gun.
I mean...
Oh, right after they get appointed as PR,
there are exceptions for estate sales. You can sell guns in some of those circumstances, I think.
Yeah.
Without an FFL, yet that's the first thing. Well, first of all, if they call you and tell you they've done it, why are you calling me? I mean, okay, that's like, I just shot my wife. Okay, well, okay, give me some money. I'll represent you if you get caught. I hate to say that, but I mean, it's like that. You didn't tell them to do it. You're not involved. Okay, you got your, I mean, there's nothing I have to tell you once you've already done it. I mean, nobody's looked at the guns, nobody's examined them, we don't know. So if they've committed a crime, it's too late. Okay, so I'm not sure, as a lawyer, as a confidential relationship, I would do anything other than say, congratulations. You know, that's really all you can say. I hope you use the money well, and I hope you stay out of trouble. There's nothing else you can tell them, really. And I don't know that I would scare them. I might tell them a little bit of this, just in case it happens again or they haven't sold them all. But there are problems with that. And our client, the person we had, did have, the father had some seriously contraband illegal weapons. I mean, serious stuff. In some of them, a few got away. I don't think it was the son doing or that they couldn't be found. But, you know, if they call you, tell them, for God's sake, because there are state salespeople who will come to you with a wink and a nod and say, I can sell those for you. And they sure can. They sure can. But sometimes they aren't careful, and that's something they're going to get a huge amount of money for. So that's all I really know to tell you. Do your diligence up front, not after the fact, and it's not your problem.
Is there any way you can correct that? I mean, if you sell, if you transfer, distribute, sell a truly illegal firearm, like an automatic weapon or a grenade launcher or something that's really you're not supposed to have, I mean, technically the crime is committed. It's done, you know. You're just not supposed to do these things. The standards can be quite, now they may have under some firearms violations a claim that they didn't have the right mens rea, right? They didn't know. But I mean, you don't want to be in federal court arguing that. You know, that's not where you want to be. So I don't know any way to fix that once it's sold and the money's in your client's hand.
That would come under the heading of damage control. So from there on out, you can run interference and see what you can do to mitigate it.
Right.
Depending on, you know, what happened, how bad it was, what was actually sold, to whom, and what's going on now, and can you control the client? Will they listen?
The only thing I know you can do is if the ATF or law enforcement found out about it later, just be prepared to say who did the estate sale or who you sold it to, and don't hide the fact. That's all you can do, because if you do and you mislead the police or the ATF about what happened, then you potentially have 1,001 or obstruction of justice charge on top of it, and they are going to indict you for that.
Any other questions? That's a good question. Yes, ma'am.
What if you have somebody call you and they say they're inheriting their grandfather's estate, didn't know what was in it, and they're actually a prohibited person, they're a felon or something, you know? And that's
Well,
sort of mine.
then they need to be out of possession of it. Maybe, you know, somebody else who is able to
Can
possess
you
it.
repeat?
I'm sorry, the question is, what if a person calls you that says they seem to have inherited some firearms from a relative, but they're prohibited by law from possessing firearms? So my answer is, then they need to not possess them. It's pretty simple. You can help them maybe get it transferred to someone who can possess them and hold them, maybe a licensed dealer or maybe another family member who's not prohibited, who could just hold them, keep possession of them while you sort it out. Of course, that's assuming none of the guns are illegal per se, like a machine gun, something like that.
I think with a large cache of guns like that, if you get it, he's right. If you can give it to another family member, that's the quickest thing to do. And the other thing to do is have somebody come in quickly and look at them and be sure you know what they are, because you're going to need to do that to really sell them anyway.
Somebody up there has a question, I think.
Say you have a client who's trying to do estate planning.
Do what?
Estate planning. And, you know, barring NFA firearms or items, they ask you for your advice on putting them in trust. How would y'all approach that?
Repeat?
A person has a firearms collection and they're doing some estate planning and they're wondering about the prospect of putting those firearms into a trust. I don't do a lot of that, but I know a little bit about it, maybe enough to be dangerous. First of all, there's the so-called NFA trust, and that was, I think Mr. Steve does that sometimes, but the purpose of the NFA trust was to bypass the requirement for an individual to go through the same fingerprinting and background checks to be able to get a federal firearms machine gun stamp, an NFA stamp or a machine gun, the
Silencer.
trust could own it.
Silencer. the
A
same.
silencer or a machine gun.
And that's usually why you do it. I mean, unless you have one of those things that you need a special license or stamp for, like a silencer or a fully automatic weapon, which you can own if you have the right stamps and licenses. The problem is you can't transfer that to somebody unless they can't take it, unless they also have the same approval, which they don't. So you can put it into a gun trust, and right now, the ATF and the administration is tolerating that. I know the last administration, the Obama administration, was trying to move against it and stop it, but they were tolerating it. But absent something like that, a special firearm where you need that special license, I don't know why you'd want to put them in a trust. I don't know why you would want to do that.
And the purpose of that has kind of been defeated because I think there was a requirement passed by the ATF that now whoever was the individual trustee had to go through the same requirements as an individual, so there was no longer kind of a bypass. Somebody had to be responsible, and that person was going to be named and fingerprinted, and the gun was going to be registered. So if you're talking about just regular estate planning, well,
Why do you need a trust?
sorry?
Why do you need a trust?
Yeah, I don't, most people don't need a trust. Most people, you can will that stuff. If you will it to an individual, they can inherit that NFA item if they're named in the will and it's specifically identified, but then they have to go through the process to get the tax stamp. I think the only difference is that the fee is waived, the $200 fee.
But that's just for
Their name.
for the silencer or fully automatic weapon that you can own if you have the right stamp or license. If you just have not that kind of firearm, they don't need any approval. You can just transfer it. Now, the only other reason you might need a trust is that the person that's getting them is a minor. And so somebody else has to be a trustee of those guns until they attain their majority.
That was my next point.
Okay.
It's for a minor or somebody that you want to make sure that they get the benefit of it somehow. It's sold or liquidated for the benefit of someone, then it might be a trust item. Other than that, doing a trust do it right, costs several $1,000s, and you got to get a trust EIN number, like a social security number or employer identification number, tax ID number for the trust itself. The people who do trust tell me that, and I tell them, tell you what, give me a number, I'm going to tell them to call you. Any other questions about this topic or anything? Question in the back, yes sir.
Do you recommend people who already have their NFA firearms in a trust to go ahead and dissolve the trust and remove them out?
Do I recommend that anybody who has a firearm now under the NFA Act legally go ahead and get a trust and put it into the trust?
No.
No? Did I-
Yes, about dissolving it.
Yeah,
Right.
dissolving, you already have firearms in the trust.
Dissolving the trust?
Do you see a reason to dissolve the trust and remove them, to go through the hassle of putting them in individual?
Why would you do that? It's already done, it's a done deal. Why would I dissolve it? I mean, unless you have a reason for doing it. That'd be
I don't see any reason to do it now. The only concern I have is if you get another administration that gives the ATF different marching orders, they may just try to do some regulation or executive order to wipe out that trust situation. So you always have to have an individual. But you would get notice of that. You'd know that's going on. The only reason to move it out of the trust is if you thought for some reason the individual that you wanted to have the license and you saw the law was changing and getting tougher, you might want to go ahead and get ahead of the curve and do that. But I don't see why I would dissolve it at the moment.
But a good question nonetheless. Yes, sir.
An individual dies and leaves his gun collection to a church or a charity. The church wants it liquidated. Is there any special rules on the church that says not an individual, or how do they do that? How do they, or should they?
Well, somebody's going to be in charge of the church, the governing body, whoever would take whether they were firearms or anything that was willed in the church, and then the governing body would make a determination of how they want to liquidate those items. They may want to take some of them and arm some members of the parish, and have their own security
basically with that, my understanding is that from the ATF federal firearms law perspective, not a civil, that perspective, state law and bequeaths, wills and stuff, but you can sell stuff in the state sale. You can get, there are exceptions. You can go on the ATF website, and they have information that would do, and you can, as somebody, it doesn't make you necessarily a violation of the Federal National Firearms Act to require you to get an FFL for like an estate sale. If you're just doing it one time, if you're doing it a lot for a lot of people, you do, but like yourself. So I would assume the church want to sell those, they could tell them, take them to reputable dealers and maybe get a price for them rather than do something like an auction. There are ways to dispose of it like that without, the church running afoul of federal law.
Definitely get an independent appraisal, or somebody knowledgeable can tell you what they're worth, and maybe a second opinion on that. And if you have, by the way, that 1 gun a month, 12 guns a year, if somebody has a collection, they can sell their collection. They decide they need money. Now, you can't have a collection and sell it every month, but they will let you sell your collection at least once. And if you inherit something, you can't liquidate that.
That's right.
I'd say if you go through a dealer, you probably be starting off on the right foot, but the dealer's going to want a piece of the action too. So that's why I say let the dealer tell you something, what he thinks they're worth, and then let somebody else tell you independently what they think they're worth. It's not hard to value a thing if you know what you're doing. Who else? I love questions. That tells me what you want to hear. Well, if there are no further questions, Steve's standing over there, telling me that my time has been up, our time has been up. Watch out for those seemingly harmless proposed restraining orders in family court that, why wouldn't somebody want to keep children safe? Second Amendment is 1/10 of your civil rights. It's enumerated in the Bill of Rights. It's that important. And don't let the pursuit of property, don't put that ahead of liberty. For goodness sake, be careful of taking payment in kind. And we thank you all very much.